Hello, everyone. Welcome to today's Law Path webinar. We're going to be holding it on what type of employee should you hire for your business. Now, my name is Ryan Tan, and I'm here with the team at LawPath. We'll be joined by our in-house legal expert, Damon Murdoch, who will be going through all kinds of different things on employment today. So just as everyone's coming through the chat, I'm going to pop up a poll now. We just want to get a bit of information on what kind of business you're in, your business's focus for 2022, so we can make the webinar as relevant as possible. So I've just put out that poll. I'll just take the next few moments to fill that out. And just while everyone's coming into the webinar as well, let us know where you're coming from. So again, where are you based and what industry are you in? Perfect. So again, if you have any questions on today's webinar, please pop them in the Q&A box. We do have a chat as well, but sometimes the questions can get lost in the chat. So if you do have any questions for Damon, especially around employment, again, pop them in that Q&A box. So thank you to everyone who's filling out the poll right now. We've got about 25 responses so far. So we've got a lot of people in sales and marketing, a few different people in different industries as well. Now, definitely stay to the end of today's webinar. Damon's going to be going through what type of employee should you hire for your business. And then towards the end, there'll be a special offer for all webinar attendees who are on the call today. So whether you're a LawPath member, whether you're on our legal advice plan, you might have spoken to our lawyers before, there will be a special offer for you at the end of the webinar. So definitely stick till the end. Fantastic. I'll just wait another minute or two for people to join the webinar and fill out the poll. And again, let us know where in Australia you're at right now. So we've got a bunch of lawyers and accountants joining the webinar. We've got Barry, Brett, Aran, Helen, Ivan. Thanks for joining, everyone. It's great to have you here. Alrighty. Christine has asked a question, will this be recorded and made available? So we will be recording this webinar. The webinar will be available on our YouTube channel as always at the end of the presentation. So give us either at the end of the afternoon or tomorrow sometime, and it will be uploaded to our YouTube channel and you'll be sent an email as well. Okay, we've got another question. Great, this would be a good one for Damon. So looking to set up an enterprise agreement and some labor hire. So I'll leave that one towards the end and Damon will to pick that one up. Okay, so thank you to everyone who's filled out the poll. I'm just going to go through today's agenda of the webinar. So we're going to be going through a bit about LawPath. We're going to be going through how we can help your small business, especially around these employment matters. We'll go through Damon, who is Damon, and how can he help you with your business, especially around employment. And then we'll go through different topics as well on the webinar. So choosing an employment type that suits your business, whether you're looking to hire employees or contractors or even subcontractors, which is the best one for your needs, and the different rules and specifications within employment as well. Again, you don't want to be caught, doing the wrong thing or, doing something that's not efficient or ideal for your business. So we'll be going through that comprehensively next. And then towards the end, we'll be doing a Q&A session as well as a platform demo So all the features and services that we have to offer your business. But then if you have any questions, there's a few questions pouring in now for Damon, specifically around employment law. He will be the best one to answer those ones. So again, if you have any questions like people are doing right now, please pop them in the Q&A box on Zoom. You'll see that as a separate tab next to chat. That just prevents it getting lost in the chat as well. So I just wanted to go into what LawPath is and who are we. So LawPath, what we do is we offer smart, simple legal for small businesses. And that's our mission, is to make legals more accessible for small businesses like yourselves. Through documents, through getting legal advice that's on demand, and we even have accounting advice as well. So as it says here, we allow you to create legal documents, manage compliance, and connect with lawyers on demand in one simple platform. So while you're going to hear about all kinds of employment law and different advice for your business, the documentation side of things is equally as important. Having up-to-date and compliant legal contracts, employment agreements, employee handbooks and policies. We have over 100 different HR and employment related documentation on the platform. So again, it's a good opportunity to review your policies and procedures and even your agreements, see what you have in place. And again, maybe it's time to refresh those, or simply it might be that your agreements are fantastic and you're simply just looking to refresh elements of the agreement, such as the award and payment rates as well. So that's where we come in. Again, we've got contract management for your business. So we have 350 different legal templates on our platform, including over 100 different HR and employment related documentation. We have personalized workflows as well. So when it comes to, say, hiring or firing an employee, there are a set of procedures that give you both the legal and the non-legal steps. So again, if you're looking to hire an employee, again, what is the processes to ensure that you're remaining fully compliant, not just from the employment side of things, but setting up their single touch payroll, all the way back to, putting out a job offer, a job description, and we have some handy templates. So these personalized workflows, we've got 2 of them now specifically on employment around hiring and firing an employee, and we're continually building these out and updating them. So it's particularly helpful if you're looking to, bring on new staff. And again, it's kind of the bridge between, say, getting legal advice and just using the documents, is that it can, be a very helpful hand in linking you directly to the documents, and then giving you steps. And then from there, you can always consult with one of our lawyers to get more updated information or more specific guidance, say around, say, an employee versus a contractor. And again, that's where the booking in the legal consultations comes in and is very helpful, because again, certain parts of the agreement, when it asks you, say, about awards or probationary periods, or whether you need, a contractor versus an employee, which is the topic of today's webinar, these things, cannot be replaced other than having on-demand legal advice. And that's where the LawPath legal team, such as Damon, who will be coming on shortly, are always happy and on hand to help you with your legal needs. So I'm going to introduce Damon Murdoch here now. He is, a lot of experience. He's the head of LawPath Legal, one of the main lawyers we have on the legal advice plan. And I'm sure for people who are currently on the legal advice plan, which is a lot of you, you've interacted with Damon and you've seen him on some of our past webinars. But yeah, he has over 13 years experience in an array of different legal areas. He's a 5-star rated lawyer on our platform. So again, loves chatting with people and people love chatting with him. And he's helped over 1,000 startups and small to medium businesses. And you can see from his awards here, super highly rated. So I just want to introduce Damon to the stage and to take charge of today's webinar on employment. Thanks, Damon.
Thanks, Ryan. Hi, everybody. So what we're going to be doing today is we're going to go over different types of employment, looking at the contractors as well. And I love answering your questions, so make sure you pop in those questions in the Q&A. So let's just get straight into it. So let's look at an employment contract generally. Why do you have one? What happens if you don't have one? And what's contained in them? So obviously an employment contract is a written agreement. The main things that we're looking at with an employment contract, when you look at the benefits to an employment contract versus not having one at all, is the termination clauses, restraint to trade clauses, intellectual property, confidentiality, and non-competition. Those are primarily the main clauses that really give you extra protection than just simply going off an award rate. So let's look at each of these clauses. So first of all, an unfair dismissal is where someone's been terminated because they've been unjustly, harshly, or unreasonably terminated. Now, when you're a small business, you're deemed a small business employer, and that means that you're given the first 12 months to decide whether someone is a good fit for your business. So for instance, if you have 15 or less employees, an employee cannot bring an unfair dismissal claim against you for being terminated if they haven't been employed for 12 months. Now, if you have 15 or more employees, then it's a 6-month period. But what this means is that in essence, even if you have a probation period clause within your contract, you really have 12 months to decide whether someone's a right fit. So you can put a 3-month period or a 6-month probation period. The benefit of that is that you normally say if someone's going to be terminated within their probation period, you're only going to give them 1 week's notice if it doesn't work out. And then once the probation period expires, normally that notice period might increase up to 4 weeks. So the benefit of the probation period is that you actually don't have to pay out as much notice. Now, if we look at how much notice you actually have to give when you do terminate someone, there's 2 ways to do it. You can either put it in your employment contract, or you can just have reference to section 117 of the Fair Work Act. And 117 of the Fair Work Act is basically a table, and it says if you've been employed for 1 year or less, you get 1 week's notice. 2 to 3 years, you get 2 weeks notice. 3 to 5 years, you get 3 weeks notice, and so on. Now, a lot of employers don't use the section 117 of the Fair Work Act. And instead, what they do is they say that if either the employee or the employer are going to terminate a party, the other, or the employment contract, then they'll give 4 weeks notice. I always am a little bit cautious about putting a 4-week notice period clause into the employment contract. If someone doesn't work out, you actually have to pay out that 1 month or give that notice. So consider whether the 117 schedule is more appropriate. And in the LawPath platform, you can choose when you're answering your questions to automate your contract, whether you want to put in a notice period or whether you want to put in section 117 of the Act. It's fairly common that we get situations where people put 4 weeks notice for termination in their employment contract, and then you end up with wanting to terminate someone and realizing now you have to pay out an entire month to dismiss somebody. But two important points about the probation clause. One, you can have a notice period for the probation period and then up it to a higher notice period after that probation period. And the second important thing is just making sure you look at what that notice period is just after the probation period has expired, and having a look at an unfair dismissal, the fact that you can dismiss someone and not have a risk of being sued for an unfair dismissal if they've been employed for 12 months or less. It's basically a period that the legislation has given you to make sure someone's a right fit. Now, the next one is leave entitlements. Employment, that's all statutory. So whether that's in the employment contract or not, the end of the day is it's a mandatory law that you can't contract out of. So the employment contracts often say the leave entitlements are in accordance with law, or it spells it all out. And these are all set out in a document called the NES, which is the National Employment Standards, and it spells out all the different sick leave entitlements and so on. The next one we look at is the non-solicitation clause. I find that this is the most important clause for your business. If you are in marketing or sales or doing graphic design or whatever you are doing, let's just say that you are an SEO digital marketing agency. You spend a lot of time trying to bring in clients, spend a lot of time on Google AdWords, Facebook, finding your clients, getting them on board. And then once you get them on board, you pawn them off to one of your employees to manage that contract and be account manager. And they then end up having a personal relationship with that client. And they then could have a really close relationship, so that if your employee leaves, you run the risk of that client also leaving with that employee. What a non-solicitation clause says is it says that your employee, if they leave, they're not going to steal your clients. They're not going to do work for your clients and for the next 12 months. They're not going to entice them away. They're not going to convince them to leave. And so the non-solicitation clause is twofold. It's stealing the clients and stealing your other employees. So it also prevents one of your employees grabbing one of their colleagues and joining forces and starting up a competitive business and stealing all your clients. It's really important to have one. And I recommend it for most industries. The job title and description, that can be important when you look at the actual description of the work that they're engaged to do. There is something called constructive dismissal, and that occurs where someone is actually forced to perform duties that are outside of their job description. And so what you want to normally do is be fairly specific with the job description. If they have to do admin work, specify that there's general admin duties, things like that, so you don't run the risk of assigning them tasks that they weren't originally employed to do, and then possibly bring a claim against you for forcing them to do duties that are below their pay scale or whatever it might be. Commencement date, that's just a given. Termination provisions, again, if you don't have an employment contract, you don't really have the protections that you might need. So a good example of this is if you have a delivery driver or someone that actually has to use their vehicle, you want a clause that says, if you lose your driver's license, you can be terminated. So if there's any kind of restrictions to the employment, such as they need to come into the office 3 days a week, they need to drive a motor vehicle, they need to have a certain license, they need to, whatever it might be, you want to put those obligations in the employment contract, but you also want to put in the termination clause that you can terminate them if they breach those clauses. It's not uncommon that we do have situations where people, they need their motor vehicle for the job, but then there's nothing in the actual employment contract specified. And then when they lose their license, they can't actually fulfill their duties, but there's nothing in the employment contract that specifies that they need to actually be driving around and meeting people. So have a consideration to that. We also have a look at restraint to trade clauses. A lot of people would have heard that restraint to trade clauses aren't enforceable. They're against public policy. I said that's incorrect. If you look at the amount of cases in the courts dealing with restraint to trade clauses, they're picking up and they're generally found to be enforceable. So when we look at a restraint to trade clause, there's three main elements. One is the breadth of the actual drafting of it. What is business defined as? What is your business doing? And what is a competitive business doing? And having a clear definition of exactly what you're restraining them from doing after their employment. Also having a look at the geographical location. So how broad is it? And looking at the duration of time. How long is that restraint for? So a restraint to trade clause, for instance, says, I'm working here at LawPath as a lawyer. If I was to go start my own law firm, I would have a non-solicitation clause that says that I can't steal you guys from LawPath, and because that would be a breach of the non-solicitation clause. But then I would also have a restraint to trade clause that says that I'm not allowed to have a law firm directly selling to small businesses for a period of 12 months post my employment and within the Sydney or Melbourne CBD regions. That would be a fairly fair restraint clause because it's narrow in its approach. It's the kind of clients LawPath is targeting, the SME space. So that's quite clearly defined. The geographical location, LawPath is in Sydney, it's in Melbourne, it's on all the major cities. So that's fairly specific as well. And then look at period of time. It can't be a period of time that results in the employee losing their gainful employment. So if you have someone that's doing graphic design, or let's say marketing, digital marketing, you can't just say they're not allowed to do digital marketing for the next 5 years.
Oh my God.
And the reason why, if you were to do that, then it's probably unenforceable, and it's most likely going to be a breach of policy because you're preventing someone from being able to have gainful employment. And if it's against public policy, then it's not going to be enforceable. So we have something called cascading clauses, which is, it's like what we call a ladder clause as well. And it says, you are restrained for a period of 2 months from working in a competitive business or for 24 months. But if the court finds 24 months to be unenforceable, then that's reduced down to 18 months. And if 18 months is unenforceable, then the court's to read it as 12. So that's the general gist of employment contracts, what's in it and why you should have one, as opposed to just relying on simply just the award rate. Now, the different kind of employment we'll get into, but here's a quiz. Throw into the chat if you know the answer to number 1 and 2. So question 1, you don't need to pay a contractor super, full stop. Is that true or false? Or is it ambiguous? Or is it a trick question? Question 2, you can terminate a full-time employee with 2 weeks notice. True, false? What's the answer to that? Throw it in the chat and we'll go over those answers later. Now, a full-time employee, most of the definitions are in an award, and most employees are covered by an award rate. So you got the hospitality award, you got the manufacturing award, you've got the allied health and support workers award. The main one that a lot of people are falling into is the miscellaneous award. And it just basically says, well, if there is no other award, then this is the award that applies. And the other one that a lot of people get tied into is the professional services award. And that is essentially anyone with a technical degree, whether it's computer science, software development, things like that. So if we look at these definitions, most of these definitions are either in the Fair Work Act or in most awards. And a full-time employee is someone that works 38 hours a week. And it's a regular pattern of work, normally Monday to Friday, 9 to 5, whatever it might be. Now, you can have different kind of full-time employees. You can have a full-time employee on a fixed term. You can have a full-time employee on a project-based term, or you can have a full-time employee until terminated. Most people do the last one, and that's just you've hired them as a full-time employee or where you go. But fixed term and project-based contracts are actually quite important as well. And it's something to consider in the sense that you might be hiring an employee because you just won a big government contract, or you just won a contract for a client, and you just need this employee to service that one client. And so if that client then terminates their contract with you, you want to be able to then terminate that employee. So that's a project-based full-time contract. The other one's a fixed term, where you're only going to need them for the next year. It's used most regularly with maternity leave. You have one of your staff go on maternity or paternity leave, and then you need to bring someone else in on a full-time basis to fulfill that role until the other person comes back. That's a fixed term. You know the commencement date, you know the finish date. Now, the advantages of having a full-time employee, you probably would have experienced that full-time employees are much more loyal. They use we rather than you generally. They feel as part of a team. They have career development, opportunity for growth. Their salary increases over time, but they essentially are proud of being employed by that company. They feel like they're actually part of the growth and part of the company, and they're treated like family oftentimes. And so you end up getting higher productivity out of them generally. And payroll is really easy. It's the same amount every month, month on month, and so on. Now, the difference between a full-time and casual we'll get into, but a full-time employee gets all the employee entitlements. So they get annual leave 20 days a week or 20 days a year, sick leave 10 days a year, compassionate leave if someone in their family passes away, maternity leave if they've been employed for 12 months and ended up getting pregnant, or their partner has pregnant, or if they adopt someone, they can have their role saved for a period of 12 months. So if they leave, go, and then they come back, they have that role still there. You also have various benefits as an employee on a full-time basis, such as long service leave, which is different in every state, but generally after 5 years, it starts to tick in. And in New South Wales, for instance, once you've been employed for 5 years, if you were to be terminated on grounds of poor performance, you still get paid out your prorated long service leave. But if you resign or if you're terminated on grounds of serious misconduct, you don't get anything. Whereas if you work for 10 years, then you're guaranteed to get your long service payment. Part-time employees, they vary as well. When you look at a part-time employee, they work less than 38 hours a week, normally on a regular roster, but it can vary as well. So it might be Monday, Tuesday, Thursday, from 9 to 5, for instance, or it could be on a fixed 2-week schedule where they're working under all the modern awards. If you have a part-time employee that is on a rostered base, so like hospitality potentially, they are given a guaranteed minimum hours normally. And all part-time employees and all casual employees have a minimum shift requirement. So we have right now fairly often have tutoring. People that have a tutoring business, they hire part-time employees, or even they hire casual employees to do the tutoring. And what's happening though is they get caught up by the miscellaneous award, because the miscellaneous award says that the shift is a minimum of a 2-hour shift. So that means you can't hire a tutor to do a 1-hour tutoring session per day, because you actually have to pay them a minimum of 2 hours. And so you have to have a look at which modern award might apply to see what the minimum hour shift must be if you're hiring a part-time or casual employee. But the benefit of a part-time is, for startups, you don't have the ability to pay someone the full salary. You don't need someone on the full salary. And so it gives you a little bit of flexibility, but it also gets them trained up. It commits to them. It helps them get a mortgage. That's another thing. If you look at full-time, part-time employees over casuals and contractors, if people are looking to get a mortgage, it's much more difficult without having that full-time employment. So you're helping the employee oftentimes when you're giving them a full-time or part-time employment contract. Now, again, if you look at the part-time over the full-time, it gives a lot of flexibility to the employee. So the employee might be someone with young children. They might put their kids in daycare a couple days a week. So they have freed up a couple days. You're able to get a lot of really good resources if you're hiring part-time employees, because they can't take on the full-time job, but they might be extremely experienced and they're just looking to get back into the workforce. Or they might have their own little startup and they might just be looking for a couple hours a week. So if you're having brain drain at the moment, you can't find the right staff, you might want to look at part-time employees, because it opens up a lot of different opportunities for you in finding experienced people that come in. And then obviously seasonal work as well. Casual and part-time is better for that. Now, a casual employee, they don't get annual leave, they don't get long service leave, they don't get paid holiday, they don't get paid public holiday days, they don't get paid on sick days, they don't have to accept a shift from you, they work to a roster, you can terminate them without notice, and you only pay for them when you need them. The downfall of it is that it gives a little bit of instability to your business, because they can just simply turn down a shift and then you have to find someone to replace them. You also have it's normally have a fairly high turnover when you have casuals as well. And so if you're spending a lot of time training staff and then you're losing them, you're probably better off looking at converting them to a part-time rather than a casual. The other problem with a casual is that they're normally under an award rate. And with an award rate, you have to pay 25% in addition to the normal hourly rate that you would pay to a part-time or full-time employee. And that's to cover the fact that they're not getting paid any of their entitlements. Now, there was a case called the Work Pack case. I'll just make reference to that now. So essentially what the case said was that there was an employee, they were employed for an extended period of time as a casual. They brought an unfair dismissal claim, but under the Fair Work Act, a casual is not allowed to bring an unfair dismissal claim because they have no guaranteed right to continued employment. However, if they work systematically on a regular basis for a company, they can become a deemed part-time employee. So the tribunal, the Fair Work Commission, can look into the actual hours they've worked, the regular pattern that they worked, and say, well, although you've been paying them casual rates, and although you've classified them as a casual, they actually are a part-time employee. And if that happens, in this WorkPack case, they said, we've decided that they've actually became a part-time employee many years ago. So you need to back pay all the past entitlements that you haven't paid them. So you have to pay them for all their holiday, all their annual leave, all their public holiday pay that they never received. And WorkPack said, well, that's not fair because we've been paying them an hourly rate plus a 25% loading on top of that rate to cover that stuff. So if we're going to be ordered to now pay them all the past entitlements, then at least the extra 25% that we've been paying should be set off against that amount. And the court said no. And what that meant was that the employee got the double dip. They got the 25% on top of their hourly rate, and they got all the past entitlements. This decision was subsequently overturned by the High Court, but it basically is the principle that you as an employer have to make sure that if you have a casual, you've got to make sure that you're offering them part-time quite regularly, normally every year, and get them to refuse that part-time job so that you can confirm that they're always going to be a casual and you're not going to get called into the courts for an unfair dismissal of someone that says that they're now a part-time employee. Now, let's look at contractors. As a startup business, for instance, you can't afford an employee. You can't have, you don't have consistent work. You don't have enough revenue. So you normally would hire a contractor. And the reason for hiring that contractor is that you only pay them for what they do. You can also pay a contractor hourly rates, commission, a percentage of the work that they actually bill. You know, there's different ways to actually pay them. And so a lot of startups just hire contractors at the beginning and say, well, we will give you a 50% commission on what you bill if you're a service business. The other benefit of a contractor is that you also can hire, they can work elsewhere. So you can also get really good experienced people who don't want to go and work in a company and just work in that one business, but want to use their experience in different areas and different companies. So you can hire a contractor and it gives a lot of flexibility. One thing that you got to really be careful of is if you are hiring someone and you're giving them sweat equity. So you're saying, I'm going to give you shares in my business and you be an employee in a business. That's very much unlawful. And you'll be breaching almost every section of the Fair Work Act if you're hiring an employee for sweat equity. So if you say, I'll give you 10% of the business, work as an employee for us. You haven't paid them every fortnight under the award. You haven't paid them the minimum wage. You haven't paid them super. You haven't withheld their tax. You haven't given them a pay slip. You haven't accrued their employment entitlements. There's a slew of breaches, and you as a director can be personally liable, and you're exposing yourself to significant liabilities in the future, both personally and for the company. So if you are going to hire someone for sweat equity, they need to be put on as a contractor. If you cannot pay them their actual minimum wage and instead give them equity. So that's something else to have a look at. Now, there is quite a regular occurrence where a contractor can become an employee or a deemed employee, and in twofold. So one is a contractor can become an employee from a tax perspective with the ATO, and a contractor can become an employee from a legal perspective. And those are two different things. So one of the things is if a contractor is performing a service to you, so they're actually just performing, you know, their hourly rate to you, and they're not an incorporated company, they just have an ABN, and they're working a regular pattern of work, and they're doing a substantial amount of their income just with your company, it is likely that the ATO will eventually deem them as an employee of your business for tax purposes only. And what that means is that the ATO will require you to eventually pay their super and withhold their tax. So even if you've hired them as a contractor and the contractor is issuing you an invoice every month, the ATO could still require you to pay their super and withhold their tax. So one of the things that you want to make sure you do have in your contractor's agreement that says, if a contractor is deemed an employee for tax purposes, and you are required to withhold their tax, and you are required to pay the super, you are not going to be disadvantaged by that. And at the end of the day, the contractor might receive less in their bank, but you're still paying out the exact same amount. It's just not going to them directly. The other situation is where a contractor can become a deemed employee. I don't know if anyone remembers a company called Fedora. Fedora was a food delivery company, and there was a lawsuit that found that all of their staff were deemed employees. And that came down to the actual drafting of their contract. There's also been a case where an Uber driver was found to be an employee, but normally Uber has been successful in most of those cases. But the general elements of whether a contractor is deemed an employee is looking at the control that you have over that contractor. And if you use the marketplace or the gig economy as an example, the two general principles is that contractor able to run their own business as an enterprise for profit? Can they actually go and hire other people? Can they go and do work elsewhere? If you have a contractor's agreement that says you're not allowed to subcontract the work, you are only allowed to do the work for us, and you must wear a uniform when you go and do that work, it's highly likely that they'll eventually be found to be an employee, not a contractor. If they're found to be an employee and you haven't given them all their entitlements, you're opening yourself up to some significant exposure there that you might have to pay out all the past entitlements from when they actually became an employee. But the benefit is the features of a contractor is that you don't have to pay any of the employment entitlements. You terminate them based on the contract, and essentially it's the contract that dictates the relationship. And there's been 2 high court decisions recently that says the courts will now look primarily at what the contract says. So if you are forcing people to wear your uniforms, you might be exposing yourself, because a contractor can't run their own business as their own enterprise if they're wearing a LawPath t-shirt, but is actually a contractor, because they got to be able to run their own business. And you see this all the time in cleaning businesses where they're all hired as contractors, but they have to take certain shifts. They're not allowed to delegate the work, and they have to wear the company's cleaning uniform. So just be very careful of that, because you can expose yourself to some significant risk. But the benefit is no employment entitlements, terminate them when you want, and yeah, they don't get any sick leave and so on. Other types of employment relationships that exist is shift workers, apprentices, seasonal employment. Most of these are industry specific, like manufacturing, and all the terms are normally spelled out within the award rates. Now, there are a lot of really good apprentice and traineeship subsidies that are around. So if you are in a specific industry, have a look to see whether you can hire an apprentice to train them up, because you might be able to get a significant subsidy to the wages of that employee. Now, how do you choose whether you're going to hire a contractor or an employee? It really does come down to your own business. Is that a job that now has become available and you do need someone to fill it, and it's a full-time role? Well, you're probably going to be looking at a full-time employee, not a contractor, because normally a contractor is going to be a temporary engagement, or it won't be a full-time engagement because they're doing work elsewhere. So if you need a new role filled, it's normally full-time. If it's a pilot program that you're trying out, or you've just won a contract and you just need someone to fill those duties, then in those cases, you're probably looking at a part-time employee on a fixed term or project-based, and you put in a termination clause. If this contract is terminated with this client, then your contract is terminated as well. And if it's ad hoc, you're in hospitality, you just need someone to be working during the busy times and so on, and it's roster based, then that's going to be casual. We've kind of gone through all the differences, so I won't get into that at all anymore, other than in this table, we talk about how a contractor pay their own tax. As I mentioned, the ATO can deem them as an employee for tax purposes if they're primarily only working for your business and most of their income's coming from that one source. Now, other things that you want to have a look at, we should look into some of the questions as well and see what industry you're in, and then we can start going through those industry specific questions. But just some other considerations, looking at intellectual property. So under the Corporations Act, for instance, it says that any employee, director, or officer who misuses company information is in breach of the Corporations Act, or any of those people that breach confidentiality is in breach of the Corporations Act, or where they use information for the benefit of themselves or someone else, or to the detriment of that company. So there's a lot of laws that dictate the relationship of employee and employer, and basically all the intellectual property that's created by the employee during their office hours is owned by the company. All the everything's confidential and so on. Whereas with a contractor, those aren't guaranteed. Those aren't implied. If you hire a contractor, the contractor owns all the intellectual property in everything it creates, unless you have a contractor's agreement that says that what they create is transferred over to the company. So there's no such thing as an implied transfer of intellectual property. You can't just say that the contractor doing work for you means that that work they're doing for you is owned by you. You must have an intellectual property clause. In talking about intellectual property clauses, just briefly, we normally do what's called a three-tiered confident or intellectual property clause. So we normally say a contractor comes in, any information that they have, any intellectual property that they've already created is owned by them. And then anything that's owned by the employer is owned by them. And anything that's created for the project is owned by the employer or the company that's engaged the contractor. However, if that project intellectual property has used some of the contractor's previous intellectual property, then the contractor licenses to the company forever all the stuff that they've used in the project intellectual property. So for instance, you've hired a software developer to work on developing a piece of software that they've done before. You've hired them because you know they have experience in doing it, but you want to own that software. So you bring in the contractor has some code that they've used on a previous project, and they bring that code in, and then they build on top of it, tailoring it for your business. In that case, you want the original code that that contractor has brought into the business to be licensed to your company, and you want your company to own anything that's been built on top of it. And when you look at that license, you want it perpetual, which means it's forever, revocable, the contractor can't take it back, subcontracted or sub-transferable, which means you can transfer it to other people, or transferable, worldwide, royalty-free, so you don't have to pay for it. So those are the kind of licenses that you're looking to deal with when you're looking at intellectual property. But for an employee, you automatically own it. Now, I'll go back to Ryan so he can talk a little bit more about LawPath, and then we'll get into the questions.
Thank you so much, Damon. That was incredibly insightful. I've listened to a number of presentations that he's delivered before, and there's a lot to take in. So the good news is that there will be a recording available. And thank you so much for your questions as well. I can see there's nearly 30 different comments here and whatnot. So we'll definitely get to these. Just wanted to go briefly back into, I guess, why we exist here at LawPath. You know, we found that 80% of individuals and 87% of small to medium businesses find it difficult to access the legal services that they need. They feel that there's a general perception that it takes a long time, it's expensive, and it's complicated. And generally, some businesses, when I speak to them, they also feel that they're not within the realm of accessing legal services. They feel that they need to be at a certain level, or they're not that big to be doing things. But no matter what stage you're at, as Damon shared, if you've got anyone working, I mean, even you've got volunteers or people in there, we've got those agreements on the platform to keep you staying compliant and protect your IP as well. So again, how LawPath can help, we've got different contracts on our platform, employment agreements, over 100 different employment and HR related documentation. We've got a handbook with over 15 policies. Even if you've got a casual employee and you want to transfer them or convert them to full-time employment, there's a document for that, so you can stay fully compliant within the HR space. We've got the workflows on hiring and firing employees. So all the legal and the non-legal steps are covered within that one. And then lastly, booking in legal consultations. So if you've loved what Damon shared today and it's got you thinking, look, this is really interesting and I need to do a review of my employee contracts, or I need to review the way that you're handling things, or potentially some of the red flags you mentioned, you find yourself, in the crosshairs and you just want to check it out and just, make sure that you're doing everything by the book. This is where the legal consultations come in. So in terms of our plans, we do have 3 main flagship plans here at LawPath. We've got our Essentials Documents Library, as you can see on the left-hand side. And then what that is the 350 plus legal documents. So you can customize them. You can add your flair of your branding to it with the logos and your company information in the header. We've also got e-signature built into the platform, so you can access e-signature instead of having to pay a third-party provider. You've got it built into the platform, but not only for our documents, but for your own documents. If you have contracts, you have other documents you just want to occasionally use to sign, you can upload them in and then use that feature as well. Just with the legal documents as well, they're not just blank templates, but the templates will ask you a series of questions to fill out the information. So for example, with the employment agreements, it will ask you on the full-time one, do you have a probationary period? What award are you under? Etc. And all these different questions will kind of pre-fill and it will change the agreement. So it's a dynamic living document. But if you have any questions on these things, like what award do I fall under, or what entitlements to pay, etc., this is where the legal advice plan in the middle comes in very handy, because again, it does give you access to Damon and our team here at LawPath Legal Lawyers to access on-demand legal advice. So you'd be getting unlimited 30-minute calls with our lawyers on new legal matters, and employment and HR is one of our biggest or most popular topics, just due to the extreme breadth and depth of the topic. And also it's very dynamic, with things changing. Damon shared some cases that have been happening on, and things always changing in this space. So it's good to stay compliant with the reviews. They also do on-call legal contract review up to 4 pages. So if you have documents you want to get reviewed from the platform, or even if you have another one that you got drafted up by, say, a lawyer before, those can be reviewed on our plan up to 4 pages. So it's great for employment contracts and the like. So that's the legal advice plan. And then lastly, we have our legal and accounting advice plan. So it's everything that the essentials and the legal advice plan includes. However, it does include unlimited 30-minute calls with our chartered accountants. So we have an exclusive partnership with Pop Business. They're highly sought after chartered accountants. They've won a lot of awards. So again, if you're in need of advice from an accounting and taxation perspective, because there is a lot of crossover between the two, this is where the legal and accounting advice can come in very, very handy. And there is a crossover between the two plans where our lawyers and accountants speak to each other. So they're across what's going on in your business. And this is a rare feature that you wouldn't find commonly, because again, lawyers and accountants don't oftenly speak. So you'll get everything included, and they'll be aware of what's going on in your business. Just lastly as well, we do offer an ASIC and ATO agent service. So if you do require some company changes to be made, such as with ASIC, like directors, or an address change, etc., that is offered within the plan by our company's team here at LawPath. So just briefly, in terms of the workflow, I know I went through it briefly before, but how the workflow is, as you can see here, is that we have about 7 different workflows on the platform. So one of them is hiring an employee, one of them is dismissing an employee, and within that, there's a set different amount of steps to follow that walks you through the whole process to ensure that you stay compliant from a legal standpoint. It also does include a lot of the non-legal steps. So if you're hiring an employee, it has some tips on there's a free ebook on hiring your first employee, some tips around templates, job offers, letters, etc. There's actually a new one, hire a contractor, which has just come out. So again, it's particularly relevant from what Damon spoke about today, whether you're falling within the realm of hiring contractors for your business instead of employees. That workflow is now there as well. So again, just to reiterate all the steps that you get, hiring a contractor has around 12 different steps here. So again, part 1 is on hiring the contractor, and then it will list a lot of the different steps for you. And when you click the drop-down box, it will go through a bit more information, whether it's a template or an ebook or a direct link to a document that we have on the platform to make it super easy for you. Now we have a special webinar offer today for everyone on this call. Our legal advice plan is phenomenal for the value you get. Normally we charge it's $120 a month. Normally it's billed annually. So this is a $1,440 expense. And for the value you get, it's phenomenal. In addition to the legal advice plan, you also get access to our accelerator program. And through this accelerator program, it's where our lawyers can go through different legal aspects of your business. So one of them is actually reviewing your employment contracts and your policies to ensure you remain compliant. Other parts include reviewing your intellectual property, reviewing your privacy and insurance policies, and all that. So it's a comprehensive overview included within this legal advice plan. So you do get that included, but normally it is an annual billing of $1,440. What we've arranged for today's webinar offer is monthly billing. So if you've loved what Damon has shared and you'd love to jump on board and get a consultation, start reviewing some contracts that you have in place within the business, now would be a fantastic time to do so. You can jump on board without having to make that annual payment. You can get started with simply $120 a month. And again, this would be a yearly plan, so you can kind of get all the benefits from the accelerator program and all the benefits from different legal areas of your business. So if you are interested in this and you'd like a call back from one of our team, please pop in the Q&A box, just pop in your name and your details. We will have your phone number on file, but if not, you can key that in, and that is a confidential Q&A box, so no one else will see what's there. But that's today's webinar offer as well. If you're a client with LawPath and you have an essentials plan with us and you want to upgrade, definitely key in your details through the box as well, because you would likely have some pro rata credits on your account, which we can utilize to reduce the payment. So again, if you're interested, please pop in, just key in your name and just say, I'm interested in the Q&A box, and one of our team will give you a call straight after the webinar. So I'm going to pass it back to Damon now. We've got about 18 different Q&As here and then some stuff in the chat as well. So I'll let Damon handle this one. But if you need any further assistance from us, you've got my email there, key at a Q&A in the box. I've got a phone number or live chat as well. Thank you.
All right. Thanks, Ryan. All right. So we have someone that's looking to set up an enterprise agreement because they're a labor hire company, and they have to set up different agreements for each, or would we need to set up different agreements for each industry involved? The answer is generally no. So an enterprise agreement is something that deviates from the actual award itself. Like, for instance, Qantas will have an enterprise agreement, which in essence is if you have a bunch of employees in various different awards, it's very hard to manage the payroll and the hours and the shifts and the benefits and everything for each and every different staff. So you can make an application to the Fair Work Commission and saying, all these different awards are too complicated for us to be able to manage. We want to bring everything together and put them under an enterprise agreement just for our business, where everybody's going to be treated similarly, but they're not going to be worse off than what the actual award is. So that's exactly what the enterprise agreement does. It simplifies the awards so that all the staff fall into one, basically an award just created for your business. How do you manage sensitive IP/risk of retaliation? for contractors on a time and charge agreement. Not sure if I exactly understand, but a lot of there is something called an escrow arrangement. So if you hire, let's say, well, there's different ways to do this. So if we look at the different contractors that you can hire, one is, for instance, a software developer. The best way to engage a software developer is getting a software development agreement in place. They're technically a contractor to you, but a software development agreement, I explained to it, it's almost exactly like building a house. So in the Supreme Court of Victoria, we have the building construction intellectual property list. That means the judges hear the construction cases and the intellectual property cases. It sounds like they should be totally different, but they're pretty much the same. So if you're developing a piece of software, you're developing in milestones and stages, and you have due dates for each. And every time someone finishes a milestone, you test it, make sure it works, they get paid for it, you get the code. And essentially that's the same as building a house. You lay a concrete slab, someone comes in, they inspects it, it gets signed off, you pay for the slab. The builder then builds your frame, it gets checked, it gets signed off, they then issue an invoice, you then pay. So if you're building software, that is definitely the way you should go. That's how you're going to minimize your risk, by having staged progress claims, and you get the code at the end of each testing period before you make payment, and have due dates. So that's one way to manage your risk of retaliation. The second way is if they're doing intellectual property, use your software. Give them access to your software, and that software can normally track. So your CMS, your customer management system, whatever you're using, that will be able to see every single movement of every single person that's within your software. And if they have to store everything in that software, and you can see if they're downloading it and extracting it, then that's going to help you manage it as well, because you're going to have evidence of them stealing your data, but you're also going to have evidence of them uploading the IP into your system. And then the other one is called an escrow agent, where you and your contractor might not trust each other 100%. Contractor doesn't think they're going to get paid. You don't think you're going to get the end product that you think you're going to get paid. So you can look up what's called an escrow agent. An escrow agent, it might be a third-party server that's hosted by a third party. Everybody has access to it, but are locked in. So the contractor might upload the data into the third-party server. You can't get access to it, but once you make payment, then the contractor will release it to you and give you access to it. Or an escrow agent is also used in circumstances where you pay a lot of money for someone to give you a license to use their software, and then they go bankrupt or into insolvency, and you've just lost the software that you've just paid a lot for. You can get them to upload all their code into a third-party software where it's stored there. And if a liquidation event or a default event occurs, then you automatically get access to the code. So those are some of the ways to protect you. And then if it's time and charge agreements, you should definitely have a timesheet and you should monitor it. And if it's software and you don't know software, I normally recommend hiring someone who's has some experience in that area to sign off on the invoices. They can look, see what someone's done and make sure it's correct and then sign off. It's just like building, again, a quantity surveyor. They go in, they look at what the builder's done, they look at the invoice, they make sure the invoice matches what the work was actually done, and then they approve for the payment to go ahead. You should do the same if you don't know what you're actually looking at and whether the work's actually being done. You can call on someone that might only charge $200 or $100 an hour or $50 an hour just to have a quick glance at it before you pay an invoice. Now, Barry has a question. He says, we've used LawPath several times with Damon and Claire. Great service, always helpful with advice, and then follow on legal matters. Great service. Thank you, Barry. That's not necessarily a Q&A, but thanks for the comments. Yeah, so the way the legal advice plan works is you go through the platform, you can book in a call, you say, I don't know what document to use, I don't even know where to start. I can say, okay, well, you should probably use the contractor's agreement. Now you want to make sure that when you're filling it out, you say yes to intellectual property clause, you say yes to confidentiality, you say yes to restraint of trade, you say yes to non-solicitation clause. They then go back, they create the document, they book in a call, they upload that document into a call, and then we have a chat about explaining what the clauses say, what they need to improve upon, what else they might be missing, where they can find extra clauses. So I might say, okay, well, this document doesn't have that clause, but I recommend you go into the full-time employment contract and you grab that clause, cut and paste it and put it in there to tailor it up for you. And that's generally how the legal advice plan works. And then sometimes you just need a lawyer to help you with something completely off the track, and then we can quote you and do work for you if that's what you're looking for. Now, one of the questions again is, what risk does a founder make when the memorandum of understanding drafting intentions for a co-founder who didn't meet the KPIs need to be downgraded to technical advisor, and then the revised memorandum needs to change their role as a technical advisor. So that's more touching upon what we call vesting conditions and things like that. So a lot of the times when you create a company, you might have a CTO, a CEO, a CMO, whatever it is. You might have, you know, the three friends or two friends, three of you guys have all created the business together, and you're looking forward to getting the business start. You start the business, you each have 33%, and then someone ends up quitting after 12 months or after 6 months. Your business is in many respects dead from an investor's perspective. The reason for that is that an investor is not going to be investing into a company where you've given 33% of your business to somebody that's only worked in the business for 6 months and is not contributing anything else anymore and still has 30% vote in the business and a lot of control. So this is where we normally put most founders on what's called vesting conditions. It says we each get 33% of the business, fantastic, but over the next 4 years, there's 12 months per year. So there's 48 months over the next 4 years. And slowly but surely, you're earning 1 divided by 48 month on month. So if you, of your shares. So if you quit after 24 months, great. You get to keep 24 divided by 48, 50% of your shares, but the other 50% get bought back for nothing because you haven't earned them all. And that's what we call share vesting. So if you're putting on a co-founder or anyone, and they're actually doing services in the business, and they're supposed to be delivering services for an extended period of time, then you definitely want to put them on vesting conditions so that if they leave or get hit by a bus, whatever it might be, you're able to stop the earning of those shares. You give them what they've earned, you don't give them what they haven't earned. I had a case many years ago where my client gave 16% of the business to a CFO who ended up dying within 30 days. And my client had to pay him out. Well, he had a claim for about $3 million, even though they'd only worked in the business for 30 days. So highly recommend you do that. Now, if you have a memorandum of understanding with a co-founder where they have to meet certain KPIs and they're not meeting those KPIs, then hopefully you have vesting conditions and you can just stop the vesting and then enter into a new agreement. If you don't have that arrangement, changing the title from co-founder to technical advisor, it doesn't really matter what you do. It doesn't mean anything from a legal perspective at all. So you probably need to book in a call with a lawyer to figure out what you should do and what, but basically you should be looking at whether you can claw back some of the shares that you've given them because they haven't fulfilled their side of the bargain. The next one is, what information do you suggest should be included in a disciplinary meeting invite? So where someone isn't performing up to scratch, so there's twofold. It could either be poor performance or it could be serious misconduct, and it depends on what the situation is and whether, if it's serious misconduct, you don't really even need a disciplinary action or a meeting. Where you do under the modern award that applies to your business because you have a duty to consult. But you would basically, I guess in the invite, you could either do employment review, update. It depends on the circumstance really of what you actually specify. If you pay contractors mainly for their labor, they are employees for superannuation guarantee purposes, you may need to pay super to a fund for them. Yeah, so that's from Paul. That's probably more advice. And one of the things is that, yeah, if you are employing a contractor purely for their labor, then you're more likely not are going to have to pay them super on it if they're just a ABN holder. So, it's good to get accounting advice as well, because it's not just a legal perspective. That does come down to an accounting, whether you're withholding their tax or paying their super, primarily an accountant's question. Can I ask my client contractually to offer minimum set hours? I run a consultancy business. Can I ask my client contractually to offer? So it's not uncommon where someone will say, I'm going to be hired as a contractor, but I'm going to be setting aside time for your business. And if you expect to have me to just drop everything whenever you want me for an hour, then that's not how we operate. You must hire us at a minimum of 8 hours per week, and we charge at the hourly rate. And if you don't use us for 8 hours, and you only use us for 4, you're still paying the 8 hours. So yes, you can definitely do that. You can do a contractual minimum that they have to pay you, and that's basically your retainer fee. So it's a fixed retainer for a fixed number of hours, and they always have to pay you that amount. And if they go above that amount, then they got to pay you the extra hourly rate. I had a service agreement with my client, but there's no clause stating minimum hours, right? So I think that's tying into the other one. So that's the problem, is that now they might not use you at all. And it really just comes down to what your agreement says and what the terms are. And it might be a situation that you just need to go back and renegotiate, or terminate the contract and then renegotiate. Now, for a workplace, do we have to create different enterprise agreements for each employment status? And the answer is yes. One enterprise agreement covers all staff, all industries, all kinds. So that's what the purpose of the enterprise agreement is. Does LawPath do debt recovery? LawPath Legal, which is a wholly owned subsidiary of LawPath Technology, if you are on the legal advice plan, you can book in a call, you can talk to the lawyers, you can get guidance on what to do in terms of debt recovery. Whether we actually take it on through our law firm and do it depends on the case. Unfortunately to say, normally if it's less than $10,000, you're probably better off doing it yourself, because legal fees can get very expensive. Every state has a tribunal, and a lot of those tribunals are very good for you to run a case on your own. VCAT's probably the best. So if you have a civil claim, you can run it on your own. There's really good videos. There's really good processes there. VCAT is for Victoria Civil Administration Tribunal. Then we have NCAT, and we have QCAT. And we have similar tribunals or small claims courts throughout the country. When it comes to debt recovery, we have lawyers on the platform as well, which is in the marketplace. So you can book in your issue, and LawPath has a bunch of lawyers on the marketplace. So even if LawPath Legal can't do it, you can find a law firm on the marketplace. They'll give you a quote, they'll give you a fixed fee quote to do it, and you would be able to get your debt recovery dealt with there, but it's not actually LawPath normally that would be doing it. My business is starting to grow where there is too much work for me to complete. So, and then what employment type should I suggest for a first hire to, with the intention to keep them, but try them out first? So a lot of times, and you've tried contractors who are not very good. So in that circumstance, you're probably looking at possibly getting a casual to come in, see whether it works. If they don't work out, it doesn't matter. You can terminate them because there's no guarantee of employment. If you're hiring a full-time or part-time employee, there is a little bit of risk there by bringing them in and then making them redundant 2 months later, for instance, because you don't need them anymore. Section 31 of the Australian Consumer Law, which is Schedule 2 to the Competition and Consumer or the Competition and Consumer Act, essentially says that an employer must not mislead or deceive an employee in pre-contractual relationships or employment in relation to longevity, scope, and nature of employment. So if you're representing someone that there's a full-time role right now and that they are given that job and then 2 months and then they quit their job, they quit a really good position that they were in, they foregone the long service leave that they might have been entitled to and so on to join your business. And then 2 months later, you say, oh, sorry, we don't need this role anymore. We're going to make you redundant. There is possibility of them making a claim for misleading, deceptive conduct. So if you are going to hire someone, you don't necessarily know that it's a full-time role. You're probably better off bringing them in as a casual to try them out, or a part-time or full-time fixed-term contract for 3 months or 6 months with an opportunity to renew subject to mutual agreement, something like that. So at the end of the day, you're probably looking at full-time or part-time contract on a fixed term as a trial period. And after those 3 months have worked out, offer them a full-time position, for instance. I'm just trying to get through the questions. Maybe if we can get some of them answered. So why is part-time employment is an advantage for seasonal work? Are businesses not required to pay during off-season while there is no work at all? I have a tutoring business where I hire tutors as contractors. Part-time is advantageous to me. In the long run, but I cannot afford to pay during school holidays, hence my question. Yes, you can do part-time. You can actually set out. So part-time is a regular pattern of work for specific hours. It depends on what award applies. You're in tutoring, it's a miscellaneous award. You may be, so every award allows for company shutdown period and allowing to stand down people as well. So you might be looking at a situation where you're hiring them on set rosters or set periods of time. And if you're very clear in the employment contract that they're only going to be employed from this period to that period, then there's the company shutdown during that period, and then you're hiring them back for that period, or then they're back on, then that would work as a part-time employment contract. So something that you can definitely consider. We're having difficulties with fully understanding the update award in relation to support workers and the possibility for us to access main changes for casual. So I don't know how I would be able to answer that here. Normally, the Fair Work Ombudsman have very good updates. So if you were to type in your award and go to the Fair Work Ombudsman page, they normally would have an update identifying what is actually being changed. You can also see the actual transitional provisions where if you go to that award, you can actually see what specifically has changed. So that's probably how it would be, but your best bet's probably to reach out to LawPath. What impact would pre-existing IP clauses have on royalties? For example, if the company owns the end result, but the contractor owns the code, may this to use it. So normally, if you have an IP clause, if the contractor owns the IP, and then you've developed on top of their code to build your product, you just make sure that the contractor's agreement says that you're giving a perpetual forever royalty-free license to use their software, and then you don't have to pay the contractor any royalties. If a contractor is paid an hourly rate, then how does that contrasts against producing a result as the contractor's decision tool. I think when you're talking about the decision tool, you're talking about the ATO decision tool when deciding whether someone's an employee or a contractor. It's going to come down to the facts, and I probably can't specify here, but it's looking into a lot of different factors, whether someone is an employee, a contractor, or a deemed employee for tax purposes, where you actually have to pay super. And your best bet is just talking to an accountant or having a look at the ATO website for that. Now, we're going to have to wrap this up. Last question is from Cameron. I'm a solo founder, working full-time on my own company, not making any money yet. Strictly speaking, do I fit into an employment category when I am able to pay myself? Can I do it as a contractor for my own company? The answer is yes. You're not an employee of your own company right now. You're not an employee because you can't pay yourself a wage. You can't pay yourself super. And if you were if you were actually an employee, then you're breaching everything under the sun pursuant to the Fair Work Act. So right now you're a director, and a director has a special situation of every company where a director can get paid a director's fee. Director's fee, there's no tax withheld from that. There's no super paid on that, which means that you get stung by a lump sum tax bill at the end of the year if you've paid yourself a director fee. So a lot of times when you have a startup, you're either paying yourself a dividend or a director fee. In both of those cases, you get stung at the end of the financial year because no tax is being withheld from that. Now, you can put yourself on as a contractor and you can withhold the tax and pay super on that amount, rather than just paying yourself a director fee. I guess from a mortgage perspective or getting able to get a loan and things like that, you really want to be working towards hiring yourself as an employee so you have a consistent income. It's really hard to get loans and finance when you don't have a consistent income. But one of the things is you could do is put yourself on as a contractor to start feeding your super into that, because super is a pure expense to your business as well. So at the end of the day, though, you're not an employee until you're able to pay a minimum wage. And I think that is it. So thank you very much, everybody, for joining. If you wanted to get back onto the LawPath platform or get on the LawPath platform, talk to Ryan, enter yes now, and Ryan will fill you in again.
That's right. Thank you so much, Damon. Some great answers to questions. I know we have a lot more questions coming in now, but just due to the time that's going on, we don't have time to get through these. But if you are keen on taking up the offer to speak to Damon on the legal advice plan, got a bunch of other lawyers on different topics, please key in yes. You can either hit into the Q&A box, or you can put it into the chat as well, and we'll give you a call after this. But again, thank you so much. Laurie's enjoyed the presentation. It's a brilliant presentation, very helpful. Awesome. Confirmation of our internal PD. And that's the thing. Sometimes it's just confirmation on what you're doing. And, that's so good to get that and to know, what you're doing is on the right track. So again, thank you for everyone for joining today's webinar. Key in yes if you're keen for a callback, and one of our team will give you a call after the webinar, and we'll conclude it here. But thank you so much for attending today's webinar with LawPath.